Hello, judiciary aspirants. I hope you all are fine. Let's discuss the topic of bail, bail bond, bailable offences, non-bailable offences, and this cognizable offences, non-cognizable offences. So this lecture is very crucial, very important as far as your PCS judicial exams are concerned, mains as well as your preliminary exam. So without wasting any time, let's start. So what is bail? You see, Article 21 of the Constitution of India grants you right to life and liberty. The word here is liberty, very important in this lecture. It is concerned with bail and bail bond. So everybody is free to go wherever they want to go. They are free to travel here and there in India, except certain areas which are restricted for them to go. Otherwise, every person in India is free. They can travel, they can go. Their liberty cannot be curtailed by the police, generally and usually also. And this liberty is granted to him by Article 21 of the Constitution of India, which protects his life and liberty. But can his liberty be curtailed by the police? Because police represents the state. Police is the very important wing of the state. Basically, all the fundamental rights are granted to you by the Constitution of India, and they are against the state machinery. So can police curtail your liberty? Yes, police can. If you are guilty of an offense, if you are suspected of committing an offense, the police can curtail your liberty. The police can arrest you. You cannot take the defense that your Article 21 is being violated by the police, because there is a procedure established by law. Article 21 itself says that your liberty, even your life can be curtailed by the state if there is a procedure established by law. In America, there is due process of law. In India, there is procedure established by law. The thing is that once you commit an offense, or even if you are suspected of committing an offense, the police can arrest you, and police can bring you before the nearest Elaka magistrate within 24 hours. Can during that period you be set at liberty? Do you have any right? Yes, you have the right, and the right is given to you by the system of bail. So bail is the criteria, bail is the system given in our CRPC through which you can be granted your liberty. So even during or after the arrest, the accused can be given his liberty. He can be set at liberty through the system of bail. Bail, actually the chapter of bail is given under section 436 to 450 of CRPC. But bail itself is not defined in CRPC. Basically, bail means to set at liberty a person arrested or imprisoned by the police authorities on security being taken for his appearance at a particular place and time, usually in future in the court. So in bail, the accused is set at liberty not permanently, but only temporarily, pending the investigation or trial of the case. Now, bail can be granted either through a personal bail bond or through a surety bond. If the bail is granted through the surety bond, it is the 2 or 3 sureties to whom the custody of the accused is actually or legally given by the court or the police. It is they who has to take care of him. It is their duty to see that he doesn't run away from the clutches of the law. It is their duty to produce him before the court or the police officer as mentioned in the bail bond. So what is bail bond? That we will be doing afterwards. So actually we are doing the bail bond only. So what is bail bond? Bail bond is actually the bond which is filed by or filled by the accused if the accused himself gives his personal assurance that I will be coming back, I will be attending the court on due date given the bond. That's a personal bail bond. But if the offense committed by the accused is serious or he is a hardened criminal, then personal bail bond may not be taken from him. Then surety bond will be taken, and there may be 2 or 3 sureties which will guarantee that they are there and they will bring the accused to the police authorities when called upon to do so. They will produce him to the court when called upon to do so, or on the date mentioned in the bail bond. If the accused run away, you see there's a amount mentioned in the bail bond. If the accused tries to run away or he actually runs away, that bail bond is forfeited and the amount is recovered by the sale of his property. He must be having some title deeds of some immovable property. That property can be forfeited and it can be sold. How much it should be sold? The amount given in the bail bond, that much. So bail bond is just to deter him that in case he tries to run away or he runs away, that amount will be forfeited and he can be rearrested. And in fact, if he actually runs away after filing the bail bond, after filing the surety bond, then he is rearrested. He can be rearrested, and once he is rearrested, he will be asked to file the fresh surety bond or fresh bail bond. That's it. If earlier he filed the personal bail bond and he runs away, now he has to file the bond with sureties, no personal bail bond the second time. The amount mentioned in the bail bond varies. It can be large, it can be small, it depends upon the gravity of the offense, it depends upon the history of the accused, whether he is a hardened criminal or a first timer. It depends upon the social status, the economic status of the accused. It depends upon how much immovable property he owns. It depends upon whether he is a male or female. It depends upon whether he is a child or adult. If he is a child or if he is a minor, then bail bond may not be taken from him. Even amount may not be mentioned in the bail bond. And once a child is arrested, his parents or guardians are to be informed by the police. He has to be handed over to the child welfare protection officer. All this thing is given under the Juvenile Justice Act of 2015, and the child cannot be put in the regular jail or regular lockup along with the other prisoners. No, he cannot be put along with the adult prisoners in the jail. No, there must be a special arrangement for the child. The police must bring the child before the Juvenile Justice Board within 24 hours of arrest. That's a different chapter. We'll be discussing it on some later video. Now, as you came to know what is bail, you should also know what is bailable offence and what is non-bailable offence. Bail is granted both in bailable as well as non-bailable offence. Now, what is bailable offence? Section 2 clause A of CRPC says that offences which are shown bailable in the first schedule of CRPC are bailable, and any offence shown as non-bailable in the first schedule is non-bailable. This is the definition. So, has you got any sense? Basically, I would suggest you to go through the first schedule of CRPC. You go through your Bail Act. At the end of your Bail Act of CRPC, there is a first schedule. All the offences are mentioned in it. All the offences given in IPC are mentioned in it, serial wise. And there are columns in it: bailable offences, non-bailable offences. So you go through it. It's the only way to know what are bailable offences and which offences are non-bailable. But for your kind information, bailable offences are those which are very less serious as compared to non-bailable offences. For example, section 323 of IPC, this is voluntarily causing hurt. So this is a less serious offence. The imprisonment is also very less. But as far as murder is concerned, section 302 of IPC, rape 376, these are serious offences. These are non-bailable. So what is the difference between bailable and non-bailable? Actually, as you already know, bailable less serious offences, non-bailable more serious offences. In bailable offence, the accused has got the right to get bail from the police or the court if he is ready to give bail. If he is ready to give this bail bond, personal bail bond or surety bond. If he is ready to give bail, then only he has got the right to bail, otherwise not. So in bailable offences, he has got the right to get bail, but in non-bailable offences, he has got no right to get bail. But even then, he can be granted bail. Who will grant bail in non-bailable cases? Only magistrate will grant bail in non-bailable cases. It's not the police officer who can grant bail in the non-bailable cases. Police has got the right or power to give bail only in bailable cases. And that also only when the accused is ready to give his bail, ready to file his bail bond, personal bond or should. But in non-bailable cases, the police has got no authority to set at liberty that person. The police cannot grant him bail in non-bailable cases. It's only the magistrate or the court who can grant him bail in non-bailable cases, because these are the very serious cases. In non-bailable cases, what the police can do? Police can arrest the person in non-bailable cases. If he is accused of committing non-bailable offence, the police will arrest him. The police will take him within 24 hours to the nearest Elaka magistrate, and it is the Elaka magistrate who will decide whether to give him bail or non-bail or not. If the offence is very serious and he is a hardened criminal and there is a suspicion that he will run away, he may not be given bail. But if the court thinks that he is a first timer, he has committed the offence first time in his life, and many factors may be considered and certain conditions may be put on him as given under this 436, 437, you just read those sections of CRPC. And after putting certain conditions, he may be set at liberty, he may be given bail. So in non-bailable cases, it is the magistrate only who can grant him bail, not the police. Now, when you will see the list of offences given in the CRPC, first schedule, you will observe that usually most of the cognizable offences are non-bailable and most of the non-cognizable offences are bailable. Most of the cognizable offences are non-bailable and most of the non-cognizable offences are bailable. It means, like bailable offences, non-cognizable offences are also less serious, and like non-bailable offences, cognizable offences are serious. So generally, most of the cognizable offences or cognizable cases, you must say offences. So most of the cognizable offences are non-bailable and most of the non-cognizable offences are bailable. But you should not assume that all cognizable offences are non-bailable, and you should not assume that all non-cognizable offences are bailable. Even some cognizable offences are bailable and some non-cognizable offences are not bailable, non-bailable. For this, you have to go through the list provided in the first schedule. No hard and fast rule. You have to go through the schedule of CRPC. That's the only way to find out which offences are bailable, which offences are non-bailable, which offences are cognizable, which offences are non-cognizable. But basically, most of the cognizable offences are non-bailable and most of the bailable offences are basically non-cognizable. Apart from this, now what are cognizable and non-cognizable, we will be discussing later on. Apart from this, you should know cognizable offences. So let's do cognizable offences. Cognizable offences are those offences in which police can arrest the accused without getting the warrant from the magistrate. As I already told you, cognizable offences are serious one. So police can investigate the case themselves without getting the order or warrant from the magistrate. They can arrest the accused who is guilty of or who is suspected of committing a cognizable offence. So police has authority to arrest the accused without getting warrant from the magistrate in cognizable cases. But in non-cognizable cases, the police cannot arrest the accused without getting the warrant from the magistrate. This is the main difference. In cognizable cases, because these are the serious cases, police has to register an FIR before going on for investigation. So prior to investigating the cognizable offence, the police has first and foremost file an FIR. But in non-cognizable cases, the police cannot file an FIR. So what the police will do in non-cognizable cases? For example, a person goes to the police station. He says this has happened. It's a cognizable case. The police says that no, it's not a cognizable case, it's a non-cognizable case. It's not very serious. I will not file an FIR. So what's the process for that? So basically, in non-cognizable case, the police will not write an FIR. The police will send the informant along with the whatever the information is there to the nearest magistrate, nearest Laka magistrate. The Laka magistrate will, after going through the information given by the informant and even the information provided by the police, the Laka magistrate, if he thinks that no, this is really a cognizable case, or it seems to be cognizable case, though it's a non-cognizable case, or this case needs to be investigated. It's a non-cognizable case, but this case is serious one and it needs to be investigated by the police. So what the Laka magistrate will do? So the Laka magistrate will inform the police, or rather the Laka magistrate will order the police to investigate this case. You see, the police will investigate this case, and this order given by the Laka magistrate to the police is given under section 155 clause 3 of CRPC. So it is now when the police has to register an FIR in non-cognizable case. Earlier, the police didn't register the FIR in this non-cognizable case, but it is only after the order of the magistrate under section 155 clause 3, the police has to register an FIR. Now you will say, sir, how the police can register an FIR? Ultimately, it's a non-cognizable case. But the thing is that how will police investigate the case? Before investigating the case, the first and foremost thing is that the police has to register an FIR. So ultimately, in non-cognizable case, also the police has to register an FIR because the court has ordered, the magistrate has ordered the police to investigate the case. Otherwise, the police has no authority to investigate the non-cognizable case. But it is only because of the order of the magistrate under section 155 clause 3, the police investigates this case, and before investigating this case, the police has to register an FIR. But even then, in this case, the police cannot arrest the accused without obtaining the warrant of the magistrate, because basically it's a non-cognizable case. So these were the very important points to be remembered if you are preparing for your judiciary exams. I hope you like this lecture. Thank you very much. If any query, or if you need some coaching, or you need some query, if there is some query regarding your judicial exams, you can call me on 9646526942. I repeat, 9646526942. Thank you very much.